Hello guys, welcome back with me. Don't forget to like, comment, share and subscribe. So in this video, I would like to read an article about Houston Maritime Authority. When does maritime law apply? Perhaps most obviously, maritime law applies to events that occur on high seas. In other words, accidents that happen beyond the territorial waters of any country. Furthermore, maritime law applies to the territorial sea, which are waters within 12 miles of the shore. However, the law's applicability becomes less clear further inland. Early in the United States history, maritime law did not apply to incidents that occurred within the body of the country and therefore excluded incidents involving the Great Lakes and non-tidal inland waterways. However, throughout the 19th century, this exclusion eroded away. Maritime law is now applied to navigable waters. Waterways is deemed navigable if by itself or by uniting with other waters. It can serve as a continued highway over which commerce is or may be carried on with other states or foreign countries. Consequently, if a body of waters is completely landlocked within a single state, then it is not navigable for purpose of admiralty jurisdiction. However, a body of water doesn't need to flow between states to be deemed navigable. A body of water may be deemed navigable if it is a link in a chain of bodies of waters that can be used to service interstate commerce. Ultimately, the test is that the commerce of one state must be capable of being carried into another state or foreign country. Once this test has been passed, it is likely that maritime law will be applicable, even if it is a recreational vessel. Incidents that requires Texas Maritime Accident Attorneys. Houston Maritime Injury Attorneys exist to help injured seamen or dock workers get the compensation they need to recover from serious injuries and afford long-term medical costs that occurred offshore. That includes any accidents that occur on navigable waters, rivers and ocean, and in harbors or docks. Our maritime lawyers have represented clients who were injured in jack-up rig accidents, tugboat and barge accidents, deck accidents, commercial fishing accidents, falls overboard, cargo ship accidents, dredge accidents, outbound accidents, shipyard accidents, cruise ship accidents. One notable aspect of maritime accidents is that they're often devastating. Offshore oil rig explosions cause significant damage. Vessel collisions are frequently catastrophic, and oil platforms can unfairly change the lives of workers. Maritime lawyers fight to help workers recover the compensation they deserve, whether they're suffering after a major explosion or have injuries caused by unsafe working conditions. Where maritime attorneys represent more crew members of the Deepwater Horizon and El Faro than any other law firm, we not only understand maritime law, but the practice and culture of maritime employers. The basics of maritime law. Maritime law is derived from many sources, federal statutes and general maritime law being two of the most prominent. These sources provide some of the maritime doctrines that are commonly used in cases involving vessels and their passengers and crew. Maritime law sets forth many of the basic legal tenets associated with the sea and seaman, including seaman's right to maintenance and cure. Maintenance and cure are benefits that an injured seaman receives from an employer during the course of recovery. Maintenance includes such expenses as the seaman's rent or mortgage, utilities, property taxes, homeowner insurance, and food. Cure is similar to workers' compensation benefits for land-based employees. It covers costs related to medical treatment for the work-related injury. A seaman is someone who is a captain or crew member aboard a vessel in navigation, also similar to workers' compensation. Maintenance and cure does not require that the seaman prove any fault for the injury. The employer is required to pay. The Jones Act. The Jones Act is a federal law that gives seamen a statutory right to sue their employer for personal injury damage. However, a seaman must spend at least 30% of their time working on a vessel to qualify for the Jones Act. Not only does the Jones Act provide the seaman a statutory right to sue their employer, it also eases the burden of proof needed to prove causation between the employer's negligence and the seaman's injury. Under the Jones Act, the employer's negligence only needs to play a part in the seaman's injury rather than being a proximate cause. The Jones Act also incorporates aspects of the Federal Employment Liability Act. In particular, claims filed in state court under the Jones Act are not removable to federal court. The Death on High Seas Act. When the death of an individual is caused by a wrongful act or neglect occurring on the high seas, the Death on High Seas Act guarantees that a personal representative of the descendant can bring a claim. The Saving the Suitors Clause. Federal law establishes exclusive jurisdiction for admiralty and maritime cases in the federal district courts absent any language indicating the contrary within the statutorily created right, such as the Jones Act. However, the Saving the Suitors Clause reserves any non-admiralty remedies that may be available to an individual. An example of an admiralty remedy is a suit in which the claim is brought against the ship. That's all from me. Thank you for watching. Don't forget to like, comment, share, and subscribe.